Welcome to Guardians of Innovation, Patent and Trademark Law.
Hello and welcome to Guardians of Innovation, Patent and Trademark Law with registered patent attorney Vincent LoTempio. I am your host, Kevin Rosenquist, and in today's episode, we're diving into an essential topic for anyone navigating the world of trademarks, the 5 levels of distinctiveness. Trademarks are critical to protecting your brand and intellectual property, but understanding how distinct your mark is can make or break your case. And in this episode, Vincent will break down the 5 levels of distinctiveness from generic to fanciful and explain how they impact the strength of your trademark. Vincent, it's great to see you again.
Hey, it's great to see you, Kevin. I appreciate your help in these podcasts.
Absolutely. It's great to have you. So can you start by just telling us what the 5 levels of distinctiveness for trademarks are and how they rank in terms of protection?
Yeah, certainly. I'll list them from the strongest to the weakest. The top 3 strongest marks, and that's what the trademark office is looking for when you're an entrepreneur and you're just starting off, is fanciful, arbitrary, and suggestive marks. The bottom 2 are descriptive and generic. The bottom number 4, descriptive mark, can become distinctive. It can acquire distinctiveness over time. The bottom one, generic mark, can never be a trademark. Soap or aspirin, bicycle, you're never going to get a trademark with a generic mark, right? But a descriptive mark, let's say Best Buy or Sharp for televisions, or how about McDonald's hamburgers? You're the first time you sold one hamburger, your name is Joe McDonald and you're flipping hamburgers. Nobody recognizes it, but it can acquire distinctiveness over time.
Mm-hmm.
So originally it's very weak protection, but it can become strong. But the strongest marks right out of the box are fanciful marks, arbitrary marks, and suggestive marks. So an example of a fanciful mark is Xerox, Kodak, Google. Those are the highest level of protection because they're inherently distinctiveness and have no meaning outside, the brand context.
Right.
It's something you just made up. Arbitrary, like Apple computers or Camel cigarettes, that has no meaning either towards what you're trying to sell. It's very distinctive. And I always try to get clients to pick a suggestive mark like Dunkin' Donuts, Netflix, or Jaguar. Those are strong because it's inherently distinctiveness and you're not trying to stop somebody from using something very descriptive. If you're trying to get somebody from using bicycle in their mark or soap in their mark, you're not going to be able to stop them from doing it. So, I try to tell people, get away from descriptive and try to go towards suggestive. Very few trademark clients, understand that, even after we go through so much time explaining it to them. In fact, I had a client on the phone a couple of minutes ago that came up with a fanciful mark, and I complimented him and said, look, you're head and shoulders above most people that call. He took that lesson to heart and he came up with an arbitrary mark. The problem is that it's going to take time for you to acquire distinctiveness no matter what you have. But in the long run, the stronger mark will serve you better.
What does a business need to do to make a descriptive trademark registerable?
So, to do that, you have to use it, right? You have to, to prove that it's descriptive, to prove that it's acquired distinctiveness, even though it's descriptiveness, you're going to have to show that you've, the length that you used it, the manner of using it, what your advertising was, how many people actually saw it. Did you have a billboard on the thruway and 80 million people came by? I had an example that I had to prove a phone number acquired distinctiveness. It was an 800 number. And how did I prove it? Well, on Saturday Night Live, they made fun of them. It was Celino and Barnes, and they had the bald-headed guy and the guy with the hair on the billboard. And actually, Saturday Night Live did a skit on them. And I showed that to the trademark office. It's acquired distinctive. People recognize this number. And when we filed for that application, I included sales volume, market presence, media recognition. Those are all things that you could use to help prove that it's acquired distinctiveness over time.
How do trademark examiners evaluate the distinctiveness of a mark when reviewing a trademark application?
Well, they use that scale that we just said, right? So distinctiveness, has secondary meaning in the industry, right? People just recognize it. And, they use that scale for inherent versus acquired distinctiveness. And they've also, what they'll do is they'll do their own search to see how many people are using it. I once had an examiner on the phone tell me, look, you could argue you're just another one to the party, right? So there's 55 people using the word camel or Dove. You got Dove soap and you got Dove candy. You got Domino's pizza and Domino's sugar. And sometimes we'll type in a name and that name will be used for 57 different trademarks. And I'll say to the consumer or to my client, I'll say, well, it's a very weak mark because it's so diluted. It's like putting water into the Clorox, right? And diluting the Clorox before you wash your floor. You have a diluted mark. So many other people are using it. And again, you could use the same trademark for different classes. So if I'm selling Big Mac trucks and you're selling Big Mac hamburgers, when the guy goes to buy a hamburger, he's not confused. He's not thinking he's getting it from the truck company, right?
Right.
So, I mean, it's distinctive on its own, because it's for a different product. But the more people use it, the more diluted it gets, and there is a bigger chance for you to get sued. I always say sometimes the bear eats you and sometimes you eat the bear. Most of the time the bear eats you.
Yeah,
Right?
for sure.
Stay away from the bear. Don't try to, go Nike gumballs because you like the term Nike, right? You got to stay away from that. If everybody's using it, you got to try to come up with a mark that's distinctive to you.
Can you kind of elaborate on the concept of secondary meaning and how it applies to marks that are not inherently distinctive, such as a descriptive mark?
Secondary meaning, again, is when you put it out there. Again, it's the same thing like I talked about before, McDonald's hamburgers. When you go and see a McDonald's, you know what it means. There's not Joe McDonald back there flipping hamburgers. And same thing with Best Buy, right? They're trying to say, oh, we have the Best Buy, come to us. But afterwards, after it's been on billboards, it's been in every mall that you've seen that big yellow and blue sign. It's been on a blimp. It's been on all these cars. It has a secondary meaning. People just start to recognize it for what it is. And it's not so that's the difference between acquired distinctiveness and inherent. Inherent is when nobody's ever saw it before, it's already distinctive. Acquired distinctiveness, even though it's descriptive, it's acquired distinctiveness and has secondary meaning in the industry, and people recognize what it is by just glancing at it. So most, independent inventors that are just coming out with the new idea and trying to put a trademark to their new business, it has not acquired secondary meaning yet. It might have acquired secondary meaning closely in the geography. One of the famous cases is the Burger King case, where the Burger King in Chicago, Illinois, in one of the suburbs in Ohio or Illinois, had registered the state registration. And then the big in 1964, when the big Burger King came out and started having restaurants all over the country, the state registration sued them and said, stop using this. The court actually drew a 500-mile circle around the state one and said, look, they can't come in this circle and you can't exit this circle. You've created your distinctiveness, acquired distinctiveness within this circle, but nobody else really knows about you. This is not like 1964, like today, where everything's on the internet and instantly you're all across the country. And the court basically said that the big Burger King couldn't come in that circle. And to this date, no matter how much they try to get in that 500 miles, Burger King still hasn't got in that little circle.
No kidding.
Yeah,
Burger King's still not interesting. That's hilarious. I'll have to look that up. I'm originally from Chicago, so I'll have to check it out.
Yeah, I imagine if you just type the Burger King trademark case, it's a seminal case in trademark.
Your Best Buy example is great because it's a very generic term.
Well,
you know what I mean?
Not really generic. We're calling it descriptive, right? Generic is that, and you know what? Sometimes we have this argument with the examiner when we're trying to register it, and they're saying, we're not even going to let you put it on the supplemental register because it is too close to being generic. So, that's always, it's a fine line, it's a fine line to define it, between generic and descriptive. You got to remember that a generic mark can never be registered. Like you're never going to stop somebody from selling soap and using the word soap in it, right?
I see what you're saying. I see what you're saying. So generic to the product, because the term, hey, this is a Best Buy is a seemingly generic term, but in the scope of trademark, it's not generic, it's descriptive.
Exactly.
Gotcha. Okay.
Yeah.
So how does the distinctiveness of a mark impact its chances of being successfully registered with the USPTO?
Yeah, I mean, it's absolutely the only thing they're looking at.
Okay.
They're going to say, is it distinctive? Because what they're trying to do is protect the consumer and protect the manufacturer of the goods. So me as a consumer going into the Dick's Sporting Goods and I'm going to buy a pair of Nike sneakers, I have to know that Adidas or Puma or somebody else can't put this logo on their mark. And whether I like Nike or I hate Nike and I don't want to buy it, me as the consumer, I have to know where it's the source of the goods are, who's the manufacturer of the goods. And me as the manufacturer, I have to know that all this hard work that I put into making goodwill in the community and selling my sneakers and my name is not going to be taken away from me. So what the examiner does is look at it. What is the possibility? What is its likelihood of confusion is the terms of art that a consumer would be confused when they looked at it. And there's a whole checklist of things that they go through, like, the type of goods, the channel of trade, like going back to the example of the Big Mac hamburger versus a Big Mac truck. When I'm buying $1 million truck, I'm probably going to investigate who I'm buying it from and how good it is. Versus a hamburger, maybe I'm just going to stop at any hamburger store. It's not going to be a big investigation to determine who it's from. Or maybe if I'm in the store and I'm in the aisle of the checkout and there's something sitting right there and it looks like a polo pony and it's just be a quick buy and I'm just going to grab for it. Will I be confused to thinking I'm buying it from Polo, or is this trademark too close? So the bottom line is they want the consumer to be protected so they're not confused as to the source of the goods, and they want the manufacturer to be protected so that nobody's going to be confused and all their hard work and effort of getting goodwill is lost.
I know you said that things can become fanciful, but are there cases where a trademark could shift between various levels of distinctiveness over time?
Well, yeah, so they're inherently distinctive, those top three:
Right.
arbitrary, fanciful, and suggestive. They're inherently distinctive. And descriptive is not distinctive at all. It's just describing what it is. Certainly generic is not distinctive at all. It is what it is. It's soap, right? So the thing is, it can acquire distinctiveness over time, by just looking at it. And then, of course, it's how it's being viewed by the consumer. And that's why they'll actually do consumer surveys, in a trademark, lawsuit to say, if you saw this, would you be confused? Are you confused? Do you recognize that this is by Adidas? If you see this mark, have you ever seen it before? In those examples, that's going to be proof as to whether or not it's distinctive, just based on what the consumer sees it and it recognizes the difference between it. So a trademark is considered what they call a source indicator. It tells you where what's the source of this product, who's the manufacturer of it. So when that consumer goes to purchase that product, they know who they're getting it from, and that's basically distinctive. When you see it, when you see it, you know it.
What advice do you have for businesses trying to create a strong, distinctive brand name that will stand up to any trademark challenges?
Well, let's start with, picking those top three and try to stay away from the descriptive, right? Fanciful, arbitrary, and suggestive. Let's stay away from descriptive and generic marks, right? So let's just avoid those right from the start. And then when you create your mark, and I always say, look, I can't tell you what to create. If I go home and tell my wife to put blue curtains up, she's never going to do it, right? If I tell you to put blue curtains on your trademark, you're not going to do it. But what we want to, let's not try to just modify Google. Let's not try to change Lyft. Let's try to come up with your own unique name. That's pretty obvious, right? What we do as a law office, we conduct a search. So we want to look at trademarks in your industry, whether the domain name's available, what are social media handles, are they available? Those are all things that you want to be able to use to go forward with your trademark once it's done. So let's search both trademarks, domain names, and social media handles. Try to be as versatile as we can. Let's not limit it by calling ourselves Boston Electronics, right? I always say, look, you don't see Nike sporting goods. You just see Nike, right?
Right.
So let's try not to limit it. Let's just use the major part of your mark. Because at the end of the day, the sporting goods label or the electronics label is just descriptive. right? So we want to keep those descriptive aspects out of it and try to keep it very simple. Try to, pick a name that focuses on your brand identity. Choose a name that aligns with your brand's personality, values, your target audience. We certainly don't want to call ourselves the cross-eyeds or something, right? We want to have something positive. Although there was a case called the Slopes. I don't know if you read about that. That went all the way to the Supreme Court, and it was an Asian band that called themselves a derogatory name towards Asians. And basically the trademark office said you couldn't get it because it was derogatory. But they said it was, against their freedom of speech, and they thought, all this attention would bring more attention to them, even though it was a kind of a negative name. So, but one of the things I always say is like make sure it's easy to spell, pronounce, remember, to type in. If you got a name, Boston Electric Stores and LLP, and it's this long ongoing thing, you realize how computers are. One letter's wrong, it won't come in, it won't work. So let's make it easy. Let's try not to cross cultural lines and have these cultural implications that are gonna, maybe come back to haunt you, like the Redskins. You saw the Redskins been around for 100 years. And one of the things that happens when you file a trademark, after 5 years, you can file what's called a statement of incontestability, where nobody can ever contest it. But there are certain things that supersede that incontestability. One is, if it's against social morals or and social morals change over time. Sure. I mean, They use the N-word all the way through Huckleberry Finn, right? And the schools are trying to take it out of it. And you don't understand that, at the time, it wasn't meant the same way it's perceived today.
Sure.
So we want to make sure that we don't have that problem down the road. Register your trademark early, right? You want to do it as soon as possible, because you don't want to have to take your 9,000 labels off of a product that's sitting in stores all across the country and saying, oh, we should have considered this before we put all these labels on and sent them all out. Let's get that registration done as soon as we can. And then once you do have the trademark, monitor to see if anybody's out there that's trying to use it, and steal your mark. Because we talked about dilution before. The more people use your mark in a way that's similar to yours is just going to dilute your mark. And so you want to make sure that you protect it in that way. And then, of course, use, lawyers like myself to help you register, make sure you do it right. When I talk to clients, I just got off the phone with a client earlier, going just through the questionnaire, and it kind of reminded me of all the reasons why I put that questionnaire together, because there's all these pitfalls. And I always say filling out a trademark application is not what I do. It's giving you all the legal advice on how to use your trademark in commerce so that it gets allowed in the trademark office, but it's also protectable when it's out there. So make sure it's done correctly. And I say, look, I do way more than just fill out an application. It's all the legal advice that goes along with it. So you really have to make sure that it's used properly in commerce and it's used as a trademark.
Great advice as always. Well, thank you for joining us on Guardians of Innovation, Patent and Trademark Law with registered patent attorney Vincent LoTempio. Visit LoTempioLaw.com for more information and to connect with Vince. And please like and subscribe to our channel and leave us a review in the comments. Vincent, always great to have you here. Thanks so much for joining.
Hey, thanks for leading me through this. I really appreciate your help.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.